Hey everybody, Zach Wolf here with another great Top 5 Tuesday. This week on Top 5 Tuesday, it's the top 5 things you need to know about the TCPA. I'm here at the Harris County Civil Courthouse right behind me. I just got out of court. It's a little rainy, but nothing will stop me from bringing you Top 5 Tuesday, and this is an important one. I was just in court, and if you're going to court, in any kind of litigation matter, you need to know about the TCPA. It is a statute that allows the defendant to file a motion to dismiss that requires the plaintiff to offer evidence to support its claims even before any discovery has taken place. So what do you need to know about it? Number 5 is that the TCPA does probably apply to your case. The TCPA protects the right to free speech and the right of association, but those terms are defined extremely broadly in the statute, and Texas courts have applied those broad definitions fairly literally. So that means that it applies to all kinds of lawsuits that you never would have thought would fall under the category of freedom of speech or freedom of association. For example, the kind of lawsuits I often handle involving non-competes and trade secrets. The TCPA often applies to those. So you should probably just assume that it's going to apply and then take a look at the statutory definitions and confirm that's the case. The number 4 thing to know about the TCPA is that it does have a commercial speech exemption. So there's an exception to where if the action is based on the defendant's commercial speech, for example, statements made to the person's customers in the sale or lease of goods or services, those may fall under the commercial speech exemption. Here's the kind of funny thing. The Texas Supreme Court has construed the other parts of the TCPA literally and very broadly, but it has interpreted the commercial speech exemption fairly narrowly. So go look at the way the Texas Supreme Court has interpreted the commercial speech exemption and see if maybe it applies. So if you're the plaintiff and you're trying to argue that the TCPA doesn't apply, that may help you. The number 3 thing to know about the TCPA is that if you represent the plaintiff, or if you are the plaintiff, and the defendant files a motion to dismiss under the TCPA, most of the time you probably want to ask for discovery. The TCPA does allow the judge to grant discovery to the plaintiff for good cause. And if you need discovery to get evidence to support the elements of your claim, that sounds like good cause to me. So file a motion, ask for discovery, explain why you need it to meet your burden under the TCPA. The number 2 thing to know about the TCPA is that if you are the plaintiff and the defendant files a motion to dismiss, you need to offer evidence to support each element of each one of your claims. Take that obligation seriously. Be careful. Don't think that you can just non-suit a claim and then not have to support it with evidence. The TCPA may still apply, and the defendant may still be able to get attorney's fees for moving to dismiss that claim that you non-suited. Also be careful about damages. You don't have to prove a specific amount of damages, but you do have to offer some evidence showing that your client has suffered some injury. So be sure to do that. The number 1 thing to know about the TCPA is that it gives a successful defendant the right to recover attorney's fees for filing the motion to dismiss and getting the cases dismissed. That's a significant shift in the balance of power between the plaintiff and defendant, and that can be a big benefit for the defendant and a big problem for the plaintiff. So those are my 5 key things that you need to know about the TCPA. It looks like maybe the rain is letting up a little bit. Anyway, are there other things about the TCPA you'd like to know or that you want to share? Let me know. And hey, thanks for watching.